There are three types of marriage recognized in Uganda: civil marriage, customary marriage, and religious marriage, which is celebrated in accordance with the rites and observance of a particular custom or faith. On a number of occasions, one may prefer to have an introduction ceremony at the home of the intended spouse. Unlike other types of marriage, civil marriage is a monogamous in nature.
That means that among the prerequisites for people celebrating a civil marriage, it's not mandatory that people should have celebrated or fulfilled all the customary practices. Unlike churches, sometimes which require parent consent, civil marriages only recognize the consent of the two people who are getting married. And once they get married, it's a lawful marriage, and it's recognized, and it excludes all other people.
Without going through the customary practices, some cultures seem not to recognize civil marriage, alleging that it undermines culture, which is an issue when someone dies.
This man who claims to bury our daughter did not pay dowry. According to culture, we call you a son-in-law proper when you pay dowry. They don't have any child with our daughter. So that makes it also another strong reason for why our daughter cannot be buried with him. These other children want to see graves. You see the graveyard there. The children of the late will not have any access to the grave of their mother.
That means that if people celebrate a civil marriage and that marriage is lawful, unless it's invited by any court, the primary next of kin is the spouse, the surviving widow or widower. And it doesn't matter whether there are some customary practices which are not celebrated. Amongst the things which can invalidate a civil marriage, not celebrating a customary marriage prior is not one of them. Therefore, this marriage, if URSB confirms that it was celebrated by them, it's lawful and it excludes all other people.
In giving her verdict in the case filed by the children of the late Lady Justice Stella Rach Amoko, a family division court judge, Justice Ketra Katunguka, decided that she should be buried at her ancestral home in Jukia Hill Ward in Nebi district, against the wish of her husband.
She's our wife in this home, and this is her home. Just as I took you to the bedroom, you have seen even her portrait in the sitting room where the portrait is, because this is her home.
However, the husband to the deceased, Ambassador James Idura Amoko, had wanted to bury her spouse in Ajumani, which was contested by the children and the siblings of the late Justice Stella Rach Amoko. The law has its about customs and practices in marriage.
Courts can take into consideration issues of culture only where the culture doesn't contradict with the written law. Where the written law says something express, then court cannot rely on culture. Court can only rely on culture to the extent that it doesn't contradict with what is already written. So if there are already precedents, if already there are written laws which stipulate what should be done in particular circumstances, then court cannot rely on culture. It can rely on culture where it doesn't contradict with what is already written.
This is because most times people die without leaving behind a will, which often elapses into disputes among family members.
Of course, under our laws, children are those people who are below 18. Where a person has not left a will, then all biological descendants, even dependent relatives, are all children. They have all shares in the person's estate, and they have a stake and they have a right, especially where a person has not left a will. So, if people are talking about their biological mother, they have an interest. So they cannot be left out. The law recognizes them, and it doesn't matter whether your parents were married at the time of death or not. The law is now to the effect that all children have a right in a share of their deceased parents' estate.
The recent incident is that of the late Supreme Court Judge Stella Rach Amoko, who died without leaving a written will.
If a person has left a will, their last wishes which are reduced in a will, the ones which take precedence. And of course, there are requirements of a valid will. If a person has not left a will, there is a High Court decision to the effect that the first person to be consulted is the surviving spouse, should make the decisions. However, because it's a High Court decision, High Court can depart on it, another High Court can depart on it, or even the Superior Courts.
The family members of Justice Stella Rach Amoko In the case they filed in High Court Family Division, addressed court about the wishes of the deceased. As her last words while at Nakasero Hospital.
And also she went on to say that please, when something happens to me, please take me home to my father and my Aunt Julia, where they are buried. So that is the message she left with me. I just want to pray one thing. I know my mother is in the village. She's close to 90 now, advanced age, very weak. Now, if something happens that we fail to take this body home.
Court can hear evidence, oral testimony of the people who she talked to. And of course, like every other evidence, it can be challenged by the opposite party. It can be corroborated by other witnesses who are there. And then the court can make a decision on whether to believe those witnesses or not. If it does, it has to give reasons. So it depends on the evidence of the people who are saying that we had or we saw this person saying. If court believes them, then the court can rely on their evidence to agree to the last wishes.
In her decision, Justice Katunguka said that since there was no evidence opposing the wishes from the deceased's spouse, the lady is entitled to her culture even in death. The lady is therefore entitled to be buried according to the culture and customs of Jonam Cultural Institute of the Rigama Kingdom in Nebi district.
We have contesting issues of whether some people are saying that she left a dying declaration, that this was her last wish. It may not amount to a will because the will is supposed to be written and other requirements, but what court is supposed to decide on is whether that amounts to her last wishes.
In the past decisions by this court, among others in the case of Naisi Bitarabeko Kasango versus Los Kabise Eseza, court ruled that although the relatives of the late Bob Kasango wanted him to be buried in Tororo as opposed to his wishes, the wife and the children had never been in Tororo, and they were taught nothing about Tororo and Japadora culture by the deceased, and therefore the deceased was buried in Toro.
He's a job, he has a home, he has father. How can we marry him at his in-laws? We have to take him back.